בוקר טוב.
Good morning, everybody.
אני מבקשת להודות מקרב
I'd
לב
like
על
to
ההזדמנות שניתנה
thank
לי
for the
לשאת דברים
opportunity given
בכנס
to
החשוב
me
הזה,
to speak in this very important
שנערך
conference
זו השנה ה-12,
for the
לקיים
12th
שיח
year
מגוון ופורה בסוגיות
with a
מרכזיות
very varied
שעל סדר יומנו
discourse
הציבורי.
in important issue.
התבקשתי לומר בפניכם
I
היום
was asked to talk to you today
דברים
about
על תפקידו של בית
the role
המשפט
of the
בקבלת
court
הכרעות
in
שיפוטיות הנוגעות
making
לביטחון
decisions that have
הלאומי.
to do with national security.
בטרם שאגש לנושא
But
הזה,
before
אני
I get
מבקשת
to
לומר
that, I'd
מילים
like to say
אחדות
just a
על
few
תקופת
words
הבחירות שבה אנו
about the
מצויים
election campaign that
בהיבטים
we're in at
שנוגעים
the moment
למערכת
with the
המשפט.
aspects that have to do with the courts.
בתקופה הזו
In this
נשמעים
time, we
בתדירות
hear
גבוהה מן הרגיל
quite often
קולות ואמירות מכל
voices
קצות
and
הקשת
statements
הפוליטית
from all the
המתייחסים
political
למערכת
arena
בתי
which have to
המשפט
do with the
ולרשות
courts
השופטת.
and the judiciary.
יש
Some
הטוענים
people
כי הרשות
argue
השופטת
that
צברה
the
כוח
judiciary
ועוצמה רבים
accumulated
מדי
too much
ולכן
power
מן
and
הראוי
therefore
להחלישה,
we should
ויש
weaken it. And
הקוראים
some people even
לבצע
call
לצורך כך
to
מהפכה
have
כזו
a
או אחרת
revolution
בנוגע אליה.
regarding the judiciary.
אחרים
Other
טוענים כי מהפכה
people
כזו כבר
argue
מצויה
that such a
בעיצומה
revolution is
בעקבות
already in its
שבירה של
midst
קונספציות
because of the
שמיוחסות לרשות
breaking of
השופטת.
concepts that are
ויש גם
related to
כאלה
the
המרחיקים
judiciary.
לכת
And other
וטוענים כי
people say
המטרה
that
להחריב
the
את הרשות
goal to
השופטת
demolish
כבר
the
הושגה.
judiciary
ועתה
was
יש
already
להתגייס
obtained, and
כדי
now we
לשקם
have to
חורבותיה.
mobilize in order to rehabilitate it.
יש להצטער על
It's
כך שגורמים
deplorable
שונים מכל קצות
for the
הקשת
fact that
הפוליטית
many
רואים לעשות
factors
שימוש
from all
במונחים כמו
political views
כוח,
use concepts
שבירה,
like power,
חורבן
breaking,
ודומיהם
catastrophe,
בהתייחסם לרשות
and things like
השופטת.
that when they talk about the judiciary.
ביקורת המופנית כלפי הרשות
Criticism
השופטת היא
against the
לגיטימית בכל
judiciary is
מדינה
legitimate in any
דמוקרטית, וכידוע
democratic
לכם,
country. And
ביקורת
as you
נוקבת
know,
מימין
even
ומשמאל אכן
poignant
מופנית לעתים
criticism
מזומנות
from the right and
גם
from the
כלפי
left is
הרשות
addressed
השופטת
also
בישראל.
to the judiciary in
אך
Israel.
בעיניי
But in my
מונחים
mind,
הלקוחים
concepts that are
מעולם מושגים
taken from
לוחמני
the world of
אין להם מקום
warfare
בשיח
are
נוקב
not
ככל
fit
שיהיה,
in a
הנוגע
discourse,
לרשות
poignant
השופטת,
as
כמו
it
גם
may
בשיח
be,
הנוגע
which has
לרשויות
to do with
השלטון
the
האחרות.
judiciary or any other government
הפרדת רשויות משמעה איזונים
entity.
ובלמים
We
מתוך
have to
דיאלוג
have
ולא
checks and
מלחמה
balances
בין
by
הרשויות.
dialogue and not war among
אנו,
the
מצידנו,
authorities.
נמשיך לדבוק בדרך
We are
שאותה
continuing
סללו שופטי ישראל
to work in the
לדורותיהם,
same path
ובמילון
that the judges
המושגים
of
שהנחה
Israel
אותם.
have created for
מילון
years.
זה ימשיך
Their
להנחות גם
dictionary is
אותנו.
going to continue to
מילות
lead us,
המפתח
and the
בו
key
הן
words are
עצמאות,
independence,
אי-תלות, והיעדר
non-dependence,
מורא,
no
לצד
fear,
מתינות,
together with
איזון,
moderation,
איפוק,
balance,
ניטרליות,
restraint,
ממלכתיות
neutrality,
ולב שומע
and
לכל
a
אדם הבא
hearing
בפנינו.
a heart to anybody
עוד
who
אני
comes
מבקשת
before
לומר
us.
כי
And I
אף
also want to say
מערכת אינה חפה
that
מתקלות
no
וכשלים.
system is
אך
perfect,
המבחן האמיתי של
but the real
מערכת
test
המתפקדת
of
היטב
a
הוא
system
ביכולת
that
שלה
functions properly
לבחון
is its
את עצמה
capability to test
ולתקן את
itself
הטעון תיקון.
and to correct.
ונדמה לי כי
And I
מערכת
think
בתי
that
המשפט כבר
the courts
הוכיחה
in Israel
כי
already
היא יודעת
proved
לטפל
that they
כנדרש
know
בכל
how
עניין
to deal
המחייב טיפול
properly with
מערכתי.
everything that needs a
כך אנו
systemic
עושים,
treatment.
כך נמשיך
That's what
לעשות.
we're doing today, and we shall continue to do
ולסיום
so.
ההקדמה הקצרה
And
בענייני
to end
דילמה, אני
this
מבקשת להוסיף
short
ולומר
introduction, I'd
כי
just like
מערכת
to
בתי
say
המשפט
that the courts in
בישראל
Israel
ניצבת איתן על
are
עמדה,
strong
וכי מאות
in their
השופטות והשופטים
position, and the hundreds
המכהנים
of
בכל ערכאות
judges, men and
השיפוט
women in all
עושים
levels,
וימשיכו לעשות את
are
מלאכתם
doing and
נאמנה
continue to do their
במקצועיות
work
ובמסירות.
with loyalty and
כמו כן אני
professionalism.
מבקשת לשוב
I also
ולהדגיש
want
כי
to
העצמאות
focus and say
המחשבתית ואי התלות
that
הפוליטית
the
הן
independence
נשמת
and
אפה של כל רשות
non-political
שופטת במדינה
dependence
דמוקרטית,
is the
וכי על
livelihood
מנת
of
שניתן
any
יהיה
judiciary in
לשמר
any
את
democratic
קווי
country
המתאר
in
החשובים
order to
והבסיסיים
maintain
הללו
these
של
basic
מערכת בתי
lines
המשפט
of
בישראל,
the system in
מן הראוי
Israel.
להותיר אותה
We have to leave it
מחוץ
out
למשחק
of the
הפוליטי.
political arena.
כך בימי שגרה
It's true in regular
ובימי
days,
בחירות
and it's
על אחת
definitely
כמה
true
וכמה.
in days of elections.
ומכאן לנושא שעליו
And
התבקשתי לדבר
to
בפניכם
the
היום,
subject at hand,
תפקידו של בית המשפט
the role of the
בקבלת הכרעות
courts in
שיפוטיות
making
הנוגעות
judicial
לביטחון הלאומי
decisions
של
that have to
מדינת
do with
ישראל.
the national security of the country.
בעת מלחמה
You know that at
מחרישים
times of
החוקים.
war,
אמירה
law
זו
is
מיוחסת
silent.
לפיקירו,
Cicero said it. He's a philosopher and a Roman speaker from the first century, but states that have a democratic liberal regime did not adopt it. For example, Lord Etkin, a British judge, said in one of the verdicts that dealt with the legitimacy of security measures during the Second World War, I want to quote him, in England, during the time of war, laws are not silent. They can change, but they speak in the same language at times of war as in times of peace. This was forever one of the pillars of freedom, one of the principles of freedom for which we are fighting now. The judges, says Lord Etkin, are between the individual and any attempt to jeopardize its freedom by the executive authority. And the judges have to make sure that every imposition should be done by law. End of quote. Israel, which is a young democracy, has the same view. Actually, we can say that if Israel would adopt the statement of Cicero, we would have a life without law and order, because it seems that Israel, after 70 years of independence, is still under a constant an existential threat. But as we know, the state of Israel saw itself committed from the day of its inception to the principle of the law and order and protecting human rights during war and during peace. By adopting this principle, Israel was not required to quote Lord Etkin. It was enough to address our sources, our Bible, in order to see these ideas. Because in the Judges, in the book of Deuteronomy, the king of Israel is commanded, when he sits on his throne, he has to read this law and to read it throughout his life. And the interpretation was that the king wages war, and it is with him, namely the book of laws, the Bible. Even when he goes to war, he still abides by the law. One of the greatest judges that we had, Judge Chaim Cohen, who knew the sources and the scriptures just as he knew law, he expressed this idea with a verdict that he wrote 40 years ago in the Kowasma case. And he said, so what is the difference between the war of the state and the war of its enemy? Because we fight under the law, and these fight by breaching the law. The moral power and the justice of the regime have to do with the maintaining of the laws of the country. If you give up this power and this justice, the regime, of course, serves the goals of the enemy. The moral weapon is as important than any other weapon, and maybe even more than that. And you don't have a more moral weapon than law and order. Anybody who should know that the order of law in Israel will never submit to its enemies. End of quote. These words of Justice Chaim Cohen illustrate the difference between the state of Israel as a state of law and the terror organizations, which are our bitter enemies, that don't see themselves abiding by any laws or any moral, and all the measures are okay for them. And in fact, the challenges facing the state of Israel by maintaining law and order, even during war and not just during peace, are more complicated with the years, inter alia, because of the strategic environment that keeps changing and is a problem today. These changes, together with the advantage that we have because of the focusing on the war inwards, has also disadvantage because of the fact that if the regime of the country is weakened, we face many more threats of enemies that don't see themselves abiding by international law or not even an internal law of their own country. And this is definitely a very complicated challenge because of the aspect of maintaining law and order even during war. But anybody who looks into the document, which is titled The Strategy of the IDF, published in April 2018, will see that even if we look at these characteristics of the threats, the state of Israel still abides by the basic idea that you have to maintain during war, just as during peace, law and order and democratic norms that have to do with human rights. Of course, with the checks and the balances that are needed. And in that strategic document of the IDF in 2018, it says the following: the state of Israel acts as a Jewish and democratic state according to the rules of moral warfare and international law, and is tested by the international community while the enemy does not do so. This has been the ethos that accompanies the IDF since its inception. It appears also in the order that was signed by David Ben-Gurion 2 weeks after the declaration of the state. And any soldier, man or woman, in the IDF have to swear to keep faith to the state of Israel, to its laws, and to its government. The essence of this ethos that we're very proud of in a Jewish democratic state is that the principles of the law and order and human rights accompany our combatants, our soldiers, at all times. A very important reflection of us we can find in words that were said recently, the outgoing Chief of Staff Eisenkot, when he was talking about criticism that was heard regarding the over-intervention of judges in the actions of the army. Eisenkot said that the military judicial is part of the power of the IDF, and it helps it with the commanders and the combatants to realize its vocation and to win the war. These important things, to me, reflect the main key that is supposed to shape the struggle of Israel in the threats on its national security, because we're talking about a struggle that is waged with the law and not out of the law, same as the judicial norms in any democratic country. In order to make sure that these judicial norms will be held, we need all sorts of mechanisms of monitoring. One of them is the judicial criticism of the Supreme Court in national security issues as part of a long tradition of the executive regime, because it's the duty of the courts to make sure that any security activity is done legally. But it's important to say that the judicial criticism that the court does is not designated, and it cannot replace the process of decision-making by the commanders. It's not the role of the court to make decisions about activities or military campaigns. The role of the courts in that context has to do with the question whether a certain security activity abides by the national and international measures that are legal. And therefore, there were quite a few appeals that were rejected during the years when it was found out that they deviate from this judicial issue and ask for the intervention of the courts in the discretion of the commanders. For example, in 2003, there was an appeal of the Doctors Without Borders that will forbid the IDF to use the tank shells, plashet, they're called, in the Gaza Strip. We're talking about a shell which has a cluster of metal nails, and when it explodes, a lot of the nails are scattered all over the place for hundreds of meters, and it is designated to hit not just a pinpoint place, but all over the place. And rejecting the appeal, the court decided that this kind of weapon is not forbidden by law because it is not its role to intervene, and it added that the state said that the scope of using this kind of weapon was organized already by the IDF in the rules that are binding for the commanders. And the question is if the conditions that are during war is under the decision of the commander, this will be the case. A similar decision was given in 2011 in another appeal of the Doctors Without Borders, where they said that the range of security that the IDF uses with artillery to the Gaza Strip are not legal. Rejecting it, the court says that we're talking about measures and activities that have to do with professional military dishes, and it's supposed to hit and to attack the Qassam rockets that were launched to Israel because they wanted to hit its inhabitants. This demand creates a difficulty because it's got all sorts of military issues that the professionals is the army and not the court. And therefore, the court decided not to intervene. We have to focus on the fact that the restraint taken by the courts in these issues is reasonable because it is accompanied with the checking of all the rules and all the directives according to which the army uses them. A verdict from just recently, which illustrates this policy of the court, was given in May 2018 in appeals that were directed against the orders of opening fire of the military in the fence in the Gaza Strip. The background to these appeals were all these mass events, very violent, with tens of thousands of Palestinians from Gaza that were organized and funded by the Hamas organization and other organizations of terror. The organizers put it as their goal to break through the fence, to infiltrate into Israel, and to perform terror activities against the Israeli security forces and to hit the Israelis who live on the other side of the fence. And in fact, this is what happened, because under the cover of these demonstrations, they created a smoke screen with igniting tires and throwing grenades and Molotov cocktails and mortars and shooting against Israeli and even explosive kites, which caused great fires in Israel in the settlement close to the fence. In one of them, they even devastated altogether the whole entrance to Israel from Gaza. And these events actually illustrate the complexity I spoke about in the beginning, because these events, the security forces were facing one of the most significant challenges that derives from the need to cope with this directive and intentional involvement that the terrorists do and the Israeli population. And it is designated in order to make it difficult to find them. There's a mass of people and you cannot find exactly who did what, and these activists do these terrorist activities under the cover of civil society. In the international court, we usually relate to two paradigms that organize from a judicial point of view executive and actives of the security forces. One is a paradigm of hostile activities at war, and the other one is the law enforcement, which has to organize the forces in situations where there are activities of maintaining law and order. Policing, in fact. To each of these paradigms, there are definite rules how to use force. But the war against terror and the terrorist organizations faces Israel, not just Israel, in the last few years, also other countries in the world, faces it with quite difficult challenges that are not exactly under one of these categories. It's either a warfare or law enforcement. And because of that, the courts were required quite often to typify the activities in concrete cases and to set criteria according to which we can decide whether it is actually a warfare, which then doesn't have the responsibility under the civil law, or not. As for the fence events, as I mentioned just now, we said that we're actually talking about events where there's a mix of both paradigms, and therefore the Israeli security forces are faced with a very complicated mission because they have to act alternatively in the same event according to the various rules that have to do with each of them. The appeals were directed against the directives of opening fire by the IDF and also against the way they are implemented against civilians who are not armed. And the state wanted to present to the court all sorts of explanations and clarifications regarding the orders of opening fire, and also a very covert intelligence material which have the orders that the IDF can use. Those who appealed were against these verdicts, and therefore we reduced the test of the opening fire directives because we found out that they are criteria of different warfares, different events, and it is a direct line to the severity of the danger and the probability of its happening. And we found out that according to the directives, exerting force with lethal potential in a concrete case have to do with the very severe principles of the need of the proportionality in the international law. Those who appealed said that because of the scope and the number of so many casualties among the Palestinians, even if the directives to open fire is legal, the use of open live fire is against the international law. And this complaint was rejected by us according to what I said before. And I said that as opposed to checking the legality of the directions of opening fire, which we of course abide by, checking the way in which these directives are implemented have to do with professional aspects. And it's doubtful whether the court has the tools to actually decide. We also related to the various mechanisms that the IDF itself does in order to draw conclusions, because the IDF, while the events are happening, always draws the conclusions according to which the forces in the field get all sorts of orders and clarifications, and there are, of course, also mechanisms to investigate extraordinary events. And I want to focus and to say that together with the policy of non-intervention that the courts take in some of these cases, the court does not hesitate to have judicial criticism when there are legal questions which are principal and justify intervention. And I can mention three very important verdicts. One of them have to do with the question whether the Shabak in its investigations can exert physical means. The other one has to do with focused foils of actions, and the third is the neighbor procedure. In all these issues, the courts have decided about what's allowed and what's forbidden from a legal point of view, and that's why it is very important, but also evoke a lot of public discourse. And the question in this context is usually if there's a place at all to judicial involvement, which has to do with the legality of fighting against terror. Some people say that the court shouldn't do with these things at all. And in an article written about judging democracy and terror, the emeritus president Aaron Barak said that these claims are heard from all the political winds. Some people say that the judicial involvement jeopardizes security, and the others say, on the contrary, that judicial activity gives legitimacy to fight against terror. In that article, Barak focused himself on a long tradition of judicial criticism about the legality of fighting against terror, which makes this war very difficult. But he ends and he says that in his mind, the law and the order is an important component in national security. And I think this is accurate. And also President Shamgar said it. He said that the law of order wasn't created from nothing. It's not something virtual. It has to be illustrated day in, day out, in the mere existence of normative orders and implementing them openly. The law and order, the public interest, and the government's approach are not contradictory. They are integrated into one another, they support one another, and help one another. The court is especially sure that these expectations will actually be implemented, but each of their government authorities is combined with it, because the national security is also based on the law and order, both inwards, into country, and also in creating the tools that enable us to cope with hostile factors from the outside. I would like to add and to say that the judicial criticism, I'd like to add and say that the judicial criticism that the Supreme Court holds against itself is not just a central component in national security. It's a source of power for the State of Israel, because first of all, it reflects the commitment of the state to law and order and making sure that there are checks and balances between the judicial, the executive authorities, and the civil society. Also, the Supreme Court knows the security needs of the State of Israel and the unique reality with which the country has to cope. And this recognition enables it to exert law in the proper way possible. And this is also the normative frame and also the interpretation. For example, in the Mar'aba affair, the court related to the verdict of the ICJ in Hague that came to the conclusion that Israel breached the international judgment by building the security fence in Judea and Samaria, whereas the Supreme Court here in Israel came to the opposite conclusion and said that establishing this fence is part of the law, and President Barak said that the facts are different. The Supreme Court in Israel knew all the facts that are here, whereas the one in Hague didn't know exactly what was going on. The third, even although the goal of the judicial criticism, it's not its goal, but it's important to give Israel international legitimacy. Whether the courts approves the legality of the security activity or not, just the mere fact that there is judicial criticism is a contribution to our national security. Because the court is non-biased, because it has such a long experience in such complicated questions of fighting against terror, the verdicts of the Israeli Supreme Court are resonating also out of Israel. They're read by foreign and international courts in universities and in government offices, and they have an impact on the way where the players in the international community also understand international law and interpret it. A very known example is the verdict in the focused targeted killings that had a great significance on the judicial discourse all over the world. And just recently, there was a verdict regarding the directives of opening fire of the IDF when it had to cope with those violent events in Gaza. Another important byproduct of the judicial criticism that we hold with issues that have to do with national security, especially if we talk about criminal enforcement, is to create the argument of the completion factor when we deal with criminal acts in the world. Because if we have real, independent, and sincere processes of checking, of investigating, of indicting, the other judicial system cannot exert their authorities regarding events that have to do with Israel. And to conclude, the uniqueness of Israeli democracy derives from the fact that the state of Israel is under existential threat from its inception until this very day. And in such reality, maintaining the principles of legal foundations and human rights is very challenging. This uniqueness of Israeli democracy and the appreciation that our court system gets because of the way it copes with all these very complicated challenges. In 1987, one of the greatest justices of the Supreme Court in the United States, Justice Brennan, mentioned it in a lecture that he gave here in the Hebrew University in Jerusalem, and he said at the time that Israel, rather than the United States, is the hope to building judicial verdicts that maintain human rights against the requirements of national security. The other countries in the world, if they live under the same dangers, we look at the experience of Israel in dealing with these crises and can find with this experience this expertise of how to have the courage to actually maintain human rights without jeopardizing its own security. That's what he said at the time. And in view of the terrorist threats and all sorts of strategic threats that unfortunately many countries in the free world are experiencing today, these words of the Justice Brennan that were said 30 years ago is a self-fulfilling prophecy. And in fact, the verdicts of the Israeli Supreme Court, especially those that have to do with the clash between the security needs of the state and the law and order and the need to protect human rights, are studied and quoted, as I said, all over the world and receive a lot of appreciation.